Huge thanks for joining us. There is a lot to cover tonight. I'm going to introduce shortly my colleague Martin Muscat to talk to us about the new tenancies legislation. As I said, there is a lot to cover. For those of you who remember, a few weeks ago, we actually planned a seminar. And for those of you who remember in the old days, a seminar was when a whole bunch of people got together in physical presence. That can't happen these days, and we've got the next best thing, which is a webinar. So again, thanks everyone for turning up tonight. The legislation took 10 years in the making for the tenancies legislation, and times have changed very rapidly and very quickly. And in 10 days, I believe it was, they had the legislation amendment emergencies measure bill 2020 to cope with the coronavirus challenges that are facing the world, our industry, and our clients as landlords, and certainly our tenants. So there is a lot to cover tonight. Again, it's amazing how they can actually get legislation what took 10 years now in 10 days. So I'm going to quickly introduce you to my colleague Martin Muscat, who's going to talk about the first part of it, the part that took 10 years, the current legislation. Now, you will note there is on the column there an opportunity for you to ask questions. We welcome you to ask as many questions. We do have a team of people in our office standing by to answer as many questions as we can, and there will be an opportunity to record tonight and send it out to you. So, ladies and gentlemen, let me introduce my colleague, head of our property management department, Martin Muscat.
Thanks, Steve. Changes to the residential tenancies laws started on the 23rd of March this year. These changes were amendments to the Residential Tenancies Act 2010 and the new Residential Tenancies Regulations 2019. The changes have been made with the aim to reduce disputes over repairs and maintenance, increase protection and certainty for tenants, and clarify the rights and obligations of tenants and landlords. Over the next 45 minutes, we will be covering the topics appearing on your screen. If there is some time at the end of my presentation, I'll answer some questions that have been commonly asked throughout this presentation. We will also be discussing how these changes affect you as a property investor and what you need to do to ensure as an owner you are complying with the current legislation. So let's start off with the first one. Minimum standards to clarify fit for habitation. Properties are already required to be fit for habitation and should already meet these basic standards. However, these new laws just enforce these requirements even further. Now, the new changes are that the property must be structurally sound, have adequate natural or artificial lighting in each room except storage rooms or garages, and have adequate ventilation. So by that they mean windows, and in bathrooms, exhaust fans. The property must be supplied with electricity or gas and have enough electricity or gas sockets for lighting, heating, and other appliances. The property must have adequate plumbing and drainage. It must have a water connection that can supply hot water for drinking, washing, and cleaning. And lastly, the property must have bathroom facilities, including toilet and washing facilities that allow user privacy. Now, by that, they mean if you have a bathroom there, it must have a door. You can't just have an open bathroom. People do need to have their privacy. Now, keep in mind that the property could have other issues that make it unfit for habitation, even if the property does meet the requirements that I have just gone over. For example, if the property is new, it may not have an occupation certificate. If something were to happen at the property, apart from the owner having a potential issue with their insurance, the tribunal may deem this property not fit for habitation as it does not meet local council requirements. Before the property is rented out, the landlord needs to ensure that the property is fit to live in. These standards must be maintained throughout the tenancy. If that means carrying out repairs, then that's what needs to be done. So another change, new smoke alarm obligations for landlords. Now, owners need to ensure that smoke alarms that are installed in the property are in good working order. Now, it's important to note that penalties do apply for landlords who fail to comply. That's really important because you don't want to be getting the penalty. Most of our clients have their smoke alarms checked and certified annually by a smoke alarm specialist like Smoke Alarms 360, which is the company that we recommend to our clients. These landlords don't need to worry about these changes, as Smoke Alarms 360 take care of all the requirements and remove the liability from yourself and onto them for any smoke alarm issues. For those who don't have a smoke alarm specialist, you should be aware of the following changes. Annual checks must be carried out to ensure smoke alarms are installed at the property are in working order. Removable batteries must be replaced in smoke alarms in the period specified by the smoke alarm manufacturer for a removable lithium battery or otherwise annually. Smoke alarms must be repaired or replaced within 2 days of becoming aware by the tenant that is not working or it's faulty. Now, this is really important because if a tenant notifies us, and in turn, for our clients that we manage properties for, if we notify you and we tell you that there is a repair with the alarm and you don't give us instructions to arrange for it to be repaired, or you don't have it repaired for whatever reason, if you manage your own property, then the tenants can get somebody to repair the smoke alarms. And yes, you do need to pay that invoice when they send it off to you. Smoke alarms must also be replaced within 10 years from the manufacture date, or earlier if specified by the smoke alarm manufacturer. Now, what a lot of you may not know is that all smoke alarms have an expiry date on them. So the smoke alarms need to be, this is why it's important to have the smoke alarms checked and certified by a qualified certifier or electrician. If something were to happen at the property and God forbid there was a fatality or somebody was injured or something like that, and it was found that the smoke alarm had expired, the landlord could be in serious trouble. Changes of a minor nature. Tenants can make changes, alterations, additions, or renovations to a property with the landlord's written consent. The list appearing on your screen are changes the tribunal would consider unreasonable for a landlord to withhold consent for. The landlord must not unreasonably, now this is really important to note, the landlords must not unreasonably withhold consent. If they do and the tenant takes the matter to the tribunal, there is a very good chance that the tenants will win. So some of these alterations, additions, or renovations that are classified minor include securing furniture to a non-tiled wall for safety reasons. So what I mean by this is the tenant might have a buffet unit and the top part of it might be very heavy, and the tenants could be concerned that the top half of it may topple over and fall onto a child. Now, it would not be unreasonable for the tenant to request that they secure this to the wall, as long as it's not tiled. Fitting a child-proof latch to an outdoor gate of a single dwelling, inserting fly screens on windows, installing or replacing an internal window covering, including curtains and removable blinds. Okay? Installing cleats or cord guides to secure blind or curtain cords. Installing child safety gates inside a property. So you might have a 2-story house and the tenant might request to install a child safety gate at the top of the stairs and the bottom of the stairs to avoid the child accessing the stairs. It would be unreasonable for you to withhold consent for that tenant to install that gate. Installing window safety devices for child safety. Now, if you own a property within a strata scheme, you don't need to worry about this because the Strata Schemes Management Act now requires all buildings to be fitted with child safety devices. So if your property is in a strata complex, you don't need to worry about this. Don't need to worry about it if you have an individual home as well, a house. However, if the tenant does say that they want it for their peace of mind, then it'd be unreasonable to withhold consent for that. Installing handheld shower heads or lever-style taps to assist elderly or disabled occupants. Installing or replacing hooks, nails, or screws for hanging of paintings, picture frames, and other similar items. Installing a phone line or an internet connection. Planting vegetables, flowers, herbs, or shrubs that don't grow more than 2 metres, in the garden if existing vegetation or plants do not need to be removed. Installing a wireless outdoor security camera. Applying shadow-resistant film to window or glass doors. And lastly, making modifications that don't penetrate a surface or permanently modify a structure, fixture, or structure of the property. Sorry, modify a surface, I should have said. Now, bear in mind that when the owners consent to these changes, you can make note that at the end of the tenancy, the property must be left how it was found. Fair wear and tear obviously must be taken into consideration. Now, if you have a property that required painting before the tenant moved into the property and they have painted it, but now have painted it a shade darker, it would be unreasonable to expect the tenant to repaint the property in the same colour. So by that I mean the tenant moves in, they find some flaking paint on the wall, they ask if they can paint it, you consent to it, and then at the end of the tenancy you say, no, I had it painted in Dulux bright white and now it's being painted in Dulux antique white. It would be, if it ended up at the tribunal, it would be very unlikely that the tribunal would rule in your favour and say that the property needs to be repainted because it is only a few shades. Now, if the room was white, however, and it did have flaking paint, but it was white, and they have painted it like a dark navy, for example, then you have a good case if the matter were to go to the tribunal because the room looks substantially different. Okay, so the next one is mandatory break lease fees for fixed term agreements. Now, some of you may be aware that previously, if the tenant broke their lease in the first half of their agreement, they would have to pay a 6-week break lease fee, and in the second half of their agreement, they would have to pay a 4-week break lease fee. That has all changed. Now, from any leases signed from the 23rd of March onwards, the new laws now apply and must be adhered to. So they are 4 weeks rent if less than 25% of the agreement has expired. 3 weeks rent if 25% or more, but less than 50% of the agreement has expired. 2 weeks rent if 50% or more, but less than 75% of the agreement has expired. And finally, 1 week's rent if 75% or more of the agreement has expired. So by way of example, if 7 months of a 12-month tenancy agreement, or 58%, has expired, a tenant would need to pay a fee equal to 2 weeks rent to the landlord to end the agreement early. Another example is if 2 months of a 6-month tenancy agreement, or 33%, has expired, the tenant would need to pay a fee equal to 3 weeks rent to the landlord to end their tenancy agreement early. Okay, so strengthen information disclosure requirements. For those investors who have a property within a strata scheme, like a townhouse or apartment, there are now material facts that you will need to help from your strata manager to answer. If you're a Devine client, you don't need to worry about asking your strata manager these questions. We will request this information from the strata managers directly. It is important to note, though, that some strata managers have come back to us and said they don't require to give us this information, and if we want, we have to do a strata search. A strata search will need to be carried out, and they are within their rights to absolutely say that. Now, in this instance, we will ask our owners to get involved as they have more sway with strata managers, and only they can really order these reports. So if a strata manager says, look, I'm sorry, I'm not giving you that information, we will pass it on to our client and we will ask for your help, but that information is vital. You can't just take a guess and say, look, you know what, just go with the flow and just select whatever. Absolutely not. We do need to have that information because it is a material fact, which we'll get on to. Now, new material facts that are being added. So, has the property been, and I should just add in there as well, that the material facts that we already have to disclose to the tenants are, still material facts that we have to disclose to the tenants. Nothing's changed there. So some of them include if the property has been subject to flooding or a bushfire in the last 5 years, we still need to disclose that to the tenant. Has a current contract for sale been prepared on the property, and is the property going to be placed on the market for sale? Yes, we still need to disclose that to the tenant. Is a driveway or walkway shared on the property? Yes, we still need to disclose all those things to the tenants. Now, for a full list of material facts, you can head over to the Fair Trading website and you can check them all out there, the old ones and the new ones. But today, I'll just go over the new ones as well. So the material facts that have been added are, has the property been used to manufacture or grow a prohibited drug or prohibited plant in the last 2 years? Okay, the answer is yes, you need to disclose that to the tenants. It is very important. Is the property in a strata scheme where scheduled rectification work or major repairs will be done to common property during the fixed term of the property? Now, this one is really, really important. And I'll give you an example. We manage several apartments in a building, in the 1970s building that has an old lift. Now, the lift is being replaced in this building and the owners were made aware. Now, keep in mind, I will reiterate, the owners were made aware. We're not made aware of what the executive committee decide is going to be done at the building. So the owners were aware that the lift was going to be out for 3 months, a period of 3 months. One of the owners in particular had a unit coming up for lease. It was a top floor unit on the 7th floor. They had a tenant move in who was 80 years of age. Now, even though the landlord at the time was not under any obligation to disclose it to us that these major repair works were going to be done, they did not have to disclose that to us, so they were perfectly fine. However, now, if they were aware that this work was going to be done and they didn't let us know, the landlord could be in some trouble. And I'll go over what some of the ramifications are shortly. If the property is part of a building where a fire, safety or building product rectification order or a notice of intention to issue one of these orders has been issued for external combustible cladding, or development or complying development certificate application or rectification has been lodged for external combustible cladding. Now, this has all come about because of that awful fire in London in that old 1960s building where it did have combustible cladding. Now, as a result of this, there were several fatalities, there were lots of injuries, so that is why this law has been introduced. Now, what happens if a landlord fails to disclose this information to a tenant? Now, this is really important. A tenant is able to end their tenancy agreement, by giving at least 14 days notice if the landlord or agent fails to comply with any of the information disclosure obligations. Okay? A tenant can also apply to the tribunal for an order to end the tenancy agreement. Okay, so they can have that formally put in writing. The tribunal also has the discretion to order the landlord to compensate the tenant for any costs incurred as a result of ending the tenancy agreement. So using that example of the one with the lift where the tenant wasn't notified, if that were to happen now and the tenant wasn't notified, then the tenant took it to tribunal, the tribunal may award the tenant moving costs because now the tenant has to move. And those moving costs could now be excessive because the lift is now out of order and the removalists have to go up and down 7 or 8 flights of stairs. The tribunal could also award the tenant a difference in rent. So the tenant may have applied, the new property that they may have taken may be an extra $10 per week. So the tribunal may say, right, in addition to paying the removals cost, the landlord now has to pay the difference of $10, being $510 as compensation to the tenant. And finally, the tribunal may also say the tenant might provide evidence and say, I've connected my internet there, I've connected electricity, I've connected gas. As a result, the tenants might have to pay a disconnection fee or a break fee of their contract, and it might be, say, $200, $300, $400. If they can supply evidence of that, then the tribunal may very well award to the tenant that those costs. So it is really important that on the material facts you do disclose them and nothing is left out. Additional water efficiency measures. So this is, a lot of them are basically the same. The first one definitely is the same. So all taps and toilets on the property need to be checked at the start of the tenancy so that any leaks are fixed. Now that is exactly the same as what the previous legislation was. What you need to keep in mind, if the tenant moves in there and they find that there are taps leaking and things like that, they're legally not required to pay water usage. So please make sure you don't have any leaking taps. Now, all toilets in rented properties must be dual flush with a minimum 3-star rating. This is not applicable to tenants though, where water usage is not charged. So you might have an old house and it's got a single flush toilet, and you may have agreed to cover the water usage charges. You don't need to worry about it in that instance. You might have a unit in an old 1970s building that only has a single flush toilet. If the property is not separately metered, you don't need to worry. You don't need to go out and change your toilet. It is perfectly acceptable to keep that toilet. But if you do have a toilet, you do have a property where you are charging the tenant's water usage, the toilet must be dual flush, and you must change that before they move in, not during the tenancy. It must be done before. Now, for any properties or for any landlords that have existing tenancies in place, okay, if it does have a single flush and the tenants bring it to your attention and they say, this toilet is a single flush toilet and I want it changed to a dual flush, then legally you are obliged to change it to fit the new legislation. So, new rectification order process. New South Wales Fair Trading now has the powers to resolve disputes between tenants and landlords over repairs and maintenance to property damage. This includes the ability to issue rectification orders. Now, this one's also really important, and I'll give you an example. We had a property a few years ago where there were leaks in multiple rooms of the property. Now, despite our repeated attempts to tell the landlord they need to fix it, the landlord refused to fix the leaks. The rooms continued to leak. They became mouldy. They became musty. It was a health issue. The tenant ended up taking the landlord to the tribunal. Now, the tribunal back then awarded the tenant a particular sum of money as compensation for putting up with all these issues. And in addition to that, they also awarded the tenant a particular amount of money per week off their rent until the repairs were completed. Now, as part of these new rectification orders, the tribunal can now also say, right, in that instance, the landlord must replace the entire roof. Now, you don't want that to happen as a landlord. You want the ball to be in your court. You want to be making the decisions on how you want to repair it. So in that instance, you could have had a situation where the roof could have been repaired for, say, $10,000. And instead, you sat around, you haven't changed it, and as a result, it's gone to the tribunal, and now the tribunal have gone, no, repairing it is not acceptable. That roof needs to be replaced. And in that particular instance with that client, it would actually work out to be more beneficial to have the roof replaced and repaired, but I still remember it cost the owner $28,000 to replace that whole tiled roof. So like I said, you want to have the ball in your court there. So we move on to another change. So the new landlord information sheet or statement. Landlords are now required to read and understand the contents of the landlord information statement, which sets out their rights and responsibilities as a landlord. Landlords and their agents cannot enter into a tenancy agreement unless they or their agent acknowledges in the tenancy agreement that the landlord has read and understood the information statement. Now, if you're one of our clients, you don't need to worry, well, you do need to worry, but we provide that peace of mind where we will send you a copy before we enter into any new agreement. We will send you a copy of the landlord information statement via email, and all you need to do is click on the link, open it. There are a couple of tick boxes to say, yes, I understood, yes, I've seen the landlord information statement, yes, I understand what it's saying, yes, I agree, yes, the property is compliant, and I'm happy to enter into a new residential tenancy agreement. You tick those boxes, you click OK, send it back, and we'll get a notification that we can then put on file, and you're totally covered in that aspect. Now, what are some of the other changes? Okay, so rent increases for periodic or continuing agreements will be limited to once every 12 months. Now, some of you might be asking the question, what is a periodic tenancy agreement? So you might have a tenant that signed a fixed term agreement for 12 months, starting on the 10th of March 2019 and ending on the 10th of March 2020. Those tenants are still living in the property. Those tenants are now on a periodic rental agreement. So they still have to abide by all the normal terms of their lease, but they are on a periodic agreement, not a fixed term agreement. Now, in that instance, okay, you can only increase the tenant's rent once in any 12-month period. Now, if you agree to renew a lease for your tenant, and this is, I doubt this would ever happen, but it may, you might agree to enter into a new 2-year residential tenancy agreement. And in that 2-year agreement, the landlord and the tenant may both mutually agree that the rent is to go up 5 times. Now, if it is written into the agreement that the rent should be increased 5 times within that 2-year period, then it is perfectly acceptable and legal for that to happen. It is only where the tenants are on a periodic lease that you can only increase the rent once in the 12-month period. Now, a new definition for separately metered to reduce disputes between tenants and landlord about who pays for electricity, gas, or water usage. Now, this is a really, really interesting one. There are some landlords out there that have properties where there are 2 dwellings on those properties. It might be a house that's divided into 2, or it might be a shop that's not separately metered. It might be a shop that's downstairs and then you have a residential property upstairs. Or you might have a house and then you might have a granny flat out the back. If the property is sub-metered, those sub-meters do not count anymore. The property must be separately metered. If you've come to an agreement with your tenant that it might be a house that's been divided into 2 and there's a little 1-bedroom flat out the back and a big 4-bedroom property out the front, it might be agreed that 90% of the electricity and 90% of the water be paid by the tenant in the bigger house and 10% of the usage be paid by the people in the smaller part of the house. That can now no longer exist, okay? If the property is not separately metered, you cannot charge your tenant any type of usage, whether it be gas, water, electricity, whatever it may be. Now, if you continue to do so, please, this is a very, very friendly warning that if the tenant does take you to the tribunal can turn around and they can say the landlord is to pay back the tenant all the money for all the usage that they have paid for. So it is really important, if you do want to charge your tenants for separate water or gas or electricity, then it is, all you need to do is work out your rate of return. It is worthwhile getting somebody out there, whether it be an electrician or Sydney Water or a plumber or something like that, to install a separate meter. There are new rules around accessing the property to take photos or videos to advertise the property for sale, or if you're going to rent it out again, and when the photos or videos can be published where the tenant's belongings are visible. So by that, it actually, this part of the legislation actually helps the landlord in quite a big aspect, but it also can slow down the process as well. Now, by that I mean, if you want to go and take photos of the property, the tenants must be given a minimum amount of notice, okay? And in that notice, you must give the tenants the opportunity to go and remove things that they don't want shown in the photograph. So it might be a personal picture or things like that. Now, when these photos are being taken, the tenant needs to consent to the photos being taken. If they don't consent, the new Act actually allows or permits the landlord to access the property with or without the tenant's permission if we've given them reasonable notice. With that said though, we do need the tenants to consent in writing that we can publish those photos. Now, if they don't consent to that in writing, that's where we come in and we act as the bad guys for you, and we point out the legislation to the tenants and say, no, you have to allow the landlord to take photos. You can't unreasonably withhold consent. And if they do, then the landlord is well within their rights to make an application to the tribunal against the tenant, okay? And the landlord contact information to be disclosed on the residential tenancy agreement. Now, this is probably the one that we hate the most. And unfortunately, it has come out there and it does need to be disclosed to the tenants. So you might be thinking, well, what's the point of employing you guys if we have to now disclose our personal information to the tenant, okay? That is why for our clients, we are highly recommending, if you have a fax number or if you have a PO box, let us give those details to the tenant rather than a phone number or an email address, because it is very easy for a tenant to pick up the phone and call you and harass you about things. It's very easy for a tenant to pick up to send an email. Whereas, you know, if you're providing a postal box address, it's harder for the tenants. Well, not harder, but for the tenants, it requires more effort. They have to go, they have to write the letter, they have to get a postage stamp, they have to post it out. Now, one of the things that we are recommending to our clients that don't have a PO box and that don't have a fax number is to set up an email alias. And by that, you might have your name might be John Smith, and your email address might be johnsmith@gmail.com. We might, as an email alias, you might set up john.smith@hotmail.com and have that redirected to come to us. So rentals@devinere.com.au. We can then look through those emails and we can sort that out without it bothering you. Now, some of you might be asking the question, oh, but hold on a minute, what happens if a tenant reports a leaking tap, for example, to me and I don't attend to it? Well, the lease very clearly states that we are acting on your behalf. We are representing you. So we are the agents on behalf of the landlord. If there is a repair, the tenants should report that repair to us, okay? If the tenant makes, you know, let's just say they've got a leaking tap and they've told the owner about, they sent the owner a fax and the leaking tap hasn't been fixed and they've turned around, they could be an opportunist tenant, and they could turn around and they could say to the tribunal, I want that tap I notified the landlord about 6 months ago, and I want to have my water usage reimbursed to me. The tribunal will turn around and they will say, well, you knew that the agent was acting on behalf of the landlord. They were your first point of contact. You failed to inform them, so therefore we are not awarding you that water usage. Now, I am going to just look at some questions. I'm going to have a question and answer time for some commonly asked questions throughout this thing, because I know a lot of you have been they're sitting down writing some questions to us. So I've got 10 minutes to answer those questions. Okay, so Morel Anderson, I should say, writes, if a 12-month lease has expired and hasn't been renewed, how does mandatory break lease fees apply? In this instance, there is no break lease fee because the lease has expired and it has not been renewed. The break lease fee only applies to tenants that are in a fixed term agreement. So thanks, Morel, for your question. I've got a question from Carly. Do we have to change toilets to a dual flush system from the 23rd of March? If someone asks me to do it tomorrow, I have to, right? Or is there a grace period? So, look, there is a grace period, and you might not be aware that the tenant doesn't have a you might not be aware that the property doesn't have a dual flush system, okay? In that instance, as soon as you are made aware that the property doesn't have a dual flush system, so we might go to the property and we might do a routine inspection, and at that routine inspection, we might find that the property doesn't have a dual flush toilet, and we might note that down. And this is, keep in mind, this is for only properties where tenants are charged water usage. If they're not charged water usage, do not worry about this. Okay, so if we've noticed it and we made a note on the routine inspection report that it's only got a single flush toilet, then you should be changing it at that point in time. If you fail to do it, and the tenant takes it to tribunal and says, I pointed it out at the last routine inspection and it hasn't been done, then the tribunal may say, right, from that point in time to now, which might be 1 month, 2 months, 6 months, 12 months, the landlord may be required to pay back that difference in water usage. So thanks, Carly, for that question. I got another question here from Amanda. It says, which website do I look for the full list of material facts to be revealed to the tenants? Now, this is a great question, Amanda. Thank you. You can have a look at this question on the Fair Trading website. So if you jump onto Fair Trading, you have a look at the legislation, you can see all the changes to the Act. They will all be, all the changes to the Act will be noted on there, but all the material facts will also be noted on there. I've got a question from Violet Lee. The new law for breaking the lease, what is the difference from the previous? So as I explained before, previously, if the tenants were in a fixed term agreement and the lease, they were on a 12-month lease, and the tenant broke their lease within the first half of the agreement, the tenants would be required to pay the landlord a set break lease fee of 6 months. 6 weeks. If they're in the second half of their agreement, the tenant will be required to pay only 4 weeks rent as a set fee. Now, as part of the changes, and I'm just going to flip back to that screen here. So now the laws are, if the tenants break their lease, okay, so 4 weeks rent is what they need to pay as a break lease fee. If the tenants, if they're in less than 25% of the agreement, if less than 25% of the agreement has expired, they need to pay 3 weeks rent if 25% or more, but less than 50% of the agreement has expired, and 2 weeks rent if 50% or more, but less than 75% of the agreement has expired, and 1 week's rent if 75% or more of the agreement has expired. So hopefully that answers your question, Violet. We'll go on to the next one. I've got a question from Chantel here. For a single rental house, do we still need to have a separate meter when tenants pay water usage? Yes, you do need to have a separately, all properties need to be separately metered now. So as I explained before, gone are the days where you can come to an agreement with the tenant where people in the front house pay 10% and people in the back house pay 90%. No, it needs to be separately metered, and when they get the bill, it needs to have meter number blah, 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 and meter number blah, 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 blah. These are the separate charges. So that is the only time you can charge a tenant water usage. Okay, last question. I've got a question from Tina here. Are landlords required to change door keys for every new tenant? No, the landlord is not required to do that at all. If the tenants move into a property and they feel like that they're not safe for whatever reason, they would like new locks, then they are, as long as they have the landlord's written consent, they are within their right, they are allowed to change the locks, but it has to be at their expense. The landlord does not need to pay for the lock to be changed. Now, the landlord might put on there, so you might have a situation, and this has happened to me not so long ago, where a tenant's written in and said they want to change the front door lock because they just don't feel secure. Now, this was a very big house, it had multiple locks, and the whole property was keyed alike. Now, the landlord was within their rights to say, I paid a lot of money to have all those locks keyed alike, so if you want to change the locks, no worries, you can change them, but all the locks must be changed and they must all be keyed alike. All right, I've got one more question, and then we have to wrap it up here. So it's a question from David Schultz, and it says, if the intercom is not working and the tenant needed to seek urgent medical attention, is it the landlord's responsibility to ensure that the intercom is in good working order, regardless of whether the body corporate wishes to do any repairs to the blocks, sorry, my apologies, to the block's intercom system? Now that is a good question. Thank you, David. Yes, ultimately it is the landlord's responsibility. So even if you might have a situation where there's a leak coming from the bathroom above your unit, and it's essentially flooding your unit, okay? Or in David's particular case with his question, an intercom system, okay? Now the body corporate might be sitting around on it, and they might say, no, we're not changing it for this reason or that reason, or they might just not be getting back to you. Ultimately, it's the landlord's responsibility, because if the tenant's upset about it and they take the matter to the tribunal, then yes, the tribunal will say the agreement is with the tenant is between the landlord and the tenant. It is not between the tenant and the owner's corporation. So yes, it will need to be up to the landlord to take matters into their own hands, get that leak fixed, get that intercom fixed, and then chase the body corporate up later for payment. And if they don't pay, then speak to your property manager. The property manager can give you advice on what avenues you should take in order to seek reimbursement from the strata manager. Okay, I'm going to put you back on to Steve. Thanks everybody for your time. If you do have any questions, please keep shooting them through because I'll be staying around while Steve is having a chat with you guys. Thanks, guys.